I am Jason Taylor with Surety Home Care, and I'm sitting with attorney Ryan Darling of Darling Law Offices. And today Ryan's going to demystify one of the greatest mysteries of the afterlife for us. And what that is how to protect our assets. What's the difference between a will and trust? So let's just jump right in. Ryan, what is the difference between a will and a trust?
They're both legal documents that people typically set up to plan their estate for when they pass away. Both documents designate who you're going to leave things to when you pass away. Both documents designate who's going to be in charge of your estate when you pass away. Perhaps the biggest difference is that when you have a will, when you pass away, that will has to go through a legal process called probate, as where with the trust, it does not. And when a probate takes place, you're making your way through the probate legal system, and like most legal systems, it is a slow moving process and can drag on for years. As where with the trust, we get to completely avoid the court system, and your family members can usually take over in a matter of a couple weeks, and we don't have to worry about the courts getting involved in monitoring everything that you're doing.
Who should have a trust?
I would say that everybody should have a trust. So in California, in order for your estate to be subject to probate, you have to have assets equaling to $184,000. Given the fact that it's almost impossible to buy real estate in Southern California for less than $184,000, if you own real estate in Southern California, I would definitely recommend that you have a trust. Especially if you have younger kids, we need to designate who's going to be their legal guardians. I have a 12-year-old son. I would hate for my estate to end up in probate and him get everything at the age of 18, because that's what happens with probate. The great thing about a trust is that in my case, is that my trust is set up to take care of my son's needs for his lifetime. And so a lot of people think that typically only older people should have trust set up. Although I agree, I also think even people my age with younger kids should have a living trust, so that we're protecting our kids.
I was you were there, Ryan. Actually, we were with a group of friends. We played golf, and I was probably in my 42, 43. And somehow or other, obviously golfers try playing with some elder folks, and they were talking about asset protection and what happens. And one of the fellows, his name was Don Borden, said, asked me, he said, "You don't have a trust?" And I said, "No." I'm thinking I'm not old enough for a trust or a will or anything at that point. And he said 3 words. He said, "You're a fool." And Don, I really respected him. So the next day or the next week, I called Ryan and said, "Hey, help me explain this to me." So let me go back to the review. So $184,000, that's a legal set amount that you have to be worth to have a trust. Did I understand that correctly?
Well, no, that's just for probate in general.
Oh,
so if you have a total of assets that are under $184,000 and you don't have a trust or a will, you probably wouldn't have to get the courts involved, depending on the value of the real estate. The problem is most people have a house and think, "Oh, I have a will, I'm leaving everything to my kids." What you don't realize is that when you pass away, your kids have to actually probate that will with the court. So now, before your kids can even sell the house or gain access to the bank accounts, everything is frozen upon your death, and we have to wait for what are called letters from the court. Here in Riverside, it typically takes about 6 weeks just to get a hearing. You're usually waiting a month just to get a death certificate. So just to get into court, you're looking at 2.5 months. Places like Orange County, it takes 6 weeks to get a hearing, but even when you get a hearing, you're usually not getting your letters for another 8 weeks. So again, we're just delaying this process of your kids gaining access to your assets when we go through the probate system. Usually people say, "I have a will, it's all taken care of," but what they don't realize is, it might be taken care of for them. It's the kids that are going to have to deal with the problem of a will. I'm personally involved in a probate right now, and it is going on almost 5 years, and the kids have been waiting 5 years to receive their inheritance because it's been dragging through the court system, and there's multiple attorneys involved. As where if an individual simply has a trust, we don't have to worry about getting in and getting a hearing date and having hearings continued with the trust. Typically, we're just waiting for a death certificate to show up for a trustee to be in charge of the estate.
So I never thought about the speed aspect before. What I'd always understood too was going to probate's expensive. It's going to come out of somebody's.
It comes out of the estate. So every attorney gets a statutory fee. It's dictated by the California Probate Code.
And that's it. It's dictated. It's set.
Well, yes and no.
Okay. Always yes and no.
Yes and no, always with lawyers. So yes, we get a set percentage of the gross value of the estate, not the net value of the estate.
So that's a big difference.
It is a big difference. So if you have a $500,000 house, but you owe $350,000 on it at the time of your death, my statutory attorney's fees are going to be based on the $500,000. Attorneys can also ask for extraordinary fees. So I have been involved in probates where other attorneys have asked for $50,000 in extraordinary fees. So probate can get really, really costly. As where if you have a trust, we don't have to worry about those statutory fees to attorneys. We don't have to worry about those extraordinary fees to attorneys. And your kids are going to wind up saving tens of thousands of dollars.
Otherwise, it just comes right out of the estate.
Yeah, most attorneys will draft wills for people and charge them a couple $100, or at least it used to be a couple $100, knowing that when you pass away, your kids are going to hire them to probate your estate, and then that's where they're going to make their money.
Oh, okay.
Yeah.
That's we won't talk about that anymore. That doesn't sound very nice. That's not a way to do it. So I'm hearing the speed, which is a tremendous factor. Imagine having to go through 5 years of trying to settle someone's estate and dealing with that all that time. It's hard to kind of put things to rest. And then, so back to those probate fees. Give me a ballpark of a percentage.
Well, it's 4% for the first 100,000, 3% for the next 100,000 after that, 2% for the next 800,000, 1% for the next 9 million. So let's say you have a modest estate of just a $500,000 house. Mm-hmm. The statutory attorney's fees on that would be roughly $13,000.
Oh, wow.
And then you're probably looking at related court costs, because the courts get involved and they always get a fee. You're probably looking at related court costs of $2,000. So off the top, you're looking at $15,000. And that's for just a modest estate. Most people are surprised as to how much they're worth because they really only look at what's in their bank account. But on paper, those assets start to add up. And when those assets start to add up, the statutory fees and probate start to add up. This is why, again, I recommend people have trusts compared to wills. Because when we have a trust, we don't have to go through the court system and we don't have to pay all of those costs.
Okay, this is an important message. I know it's a few minutes longer than your average social media video, but for that kind of money, it's worth spending an extra few minutes. Surety Home Care, we're not in the financial business. We provide in-home caregiving, but it's for elderly. So we hear these conversations, and sometimes we'll hear people say they don't have a trust, but they have a will and they're good. They don't understand the difference, and we don't want to get involved. We just say you should contact somebody. It's worth looking into. And I never even considered the time aspect, but between the time and the money, it's just something you need to do. You need to protect your assets for that that afterlife. You don't want the money to just go away to court fees. And I really appreciate my friend Ryan, but we don't want to give him all that money because you didn't make a trust. And he's one of the good ones. I've heard him tell stories of racing to the hospital to get someone to sign something because they know it's down to the wire. And if those documents don't get signed, the family's really going to hurt. It's really going to hurt on the other end. So if you're in that position, if you don't have a trust, please talk to a professional. Go talk to an attorney. Educate yourself. Of course, I'm going to suggest Ryan and the Darling Law offices. And Ryan, how long have you? It's a family business.
It's me and my father. My father has been practicing law for over 40 years. I've been working with him for the last 13 years. We've been in this building forever. This building was actually bought by my great-grandmother in the 60s, and it's been in her trust since the 60s.
Wow.
So we grew up under trust. We understand how they work and why they work.
And if you do want more information, before I even knew Ryan, I knew this corner in Riverside on Arlington and saw the building, and they've got a sign outside, and I know that they have free packets that are really well written, really comprehensive, that they just want you to have no matter where you go. But take those, read it, educate yourself, and you'll really appreciate it. Your whole family is really going to appreciate it if you do. Brian, thank you.
Thank you. Thank you.
And hopefully we can come back for some more detailed information in certain areas in the future.
Be happy to answer any questions you have.
Thanks. Okay, thank you.
Thank you.